Chapter 9 of Bailment, Section 148 to 181. Bailee is the person to whom goods are delivered. The delivery of goods by one person to another for some specific purpose is known as bailment. The delivery of goods by one person to another for some purpose upon the contract they shall, when the purpose is accomplished, be returned or otherwise deposited in accordance with the direction of the person delivering them, is a contract of bailment. Adams versus Jarvis is a leading case on bailment. Bailment is defined in section 148. When a good are delivered by one person to another for some purpose upon a contract, that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the direction of the person delivering them. The transaction is called bailment. X hire a carriage of Y. The carriage is unsafe, though Y is not aware of it and X is injured. For the injury, X and Y is liable. Which one of the following is a duty of bailee? Duty to take reasonable care of good, duty not to make unauthorized use of good, duty not to mix his own goods with the bailee goods bailed. A gratuitous bailment is terminated on the death of either of the bailer or the bailee. Finder of the lost thing, which is commonly are the subject of sale, may sell it when the lawful charges of the finder in respect of thing is found amount 2/3 of its value. Section 170 of Indian Contract Act deal with particular lien. In the law of contract, bailer is called pawner. The contract of pledge is a contract of bailment. In pledge of ownership of property or goods, continue in pleasure. The bailment of good and security for the payment or debt or performance of promisee is called pledge. The pawnee has a right to retain the goods and pledge for the payment of debt, interest, all necessary expenses in respect of good pledged. Which one of the following is correct? Pledge made by mercantile agent is valid. A leave a cow in the custody of B to take care of. The cow has a calf. In the absence of any contract to the contrary, B is bound to deliver the calf as well as the cow to A. The pledge by a seller in the possession of good after sale is valid. Chapter 10 Agency, Section 182 to 238. Under Section 182 of Contract Act, National Textile Corporation Limited is not an agent of the central government. A person employed to do an act for another or the represent in another in dealing with the third person is an agent. An agent can be appointed by the measure of sound mind. To create an agency, consideration is not necessary. In which one of the following type contract consideration is not necessary? Agency. Which one of the following statement is incorrect? B is incorrect. Which one is correct are the authority of the agent may be implied Only a person of a majority can become an agent. In emergency, an agent has authority to do an act for the purpose of protecting his principal. No consideration is necessary to create an agency. To create an agency, no consideration is necessary. Which one of the following statement is correct in relation to the sub-agent? He is employed by original agent in the business of the agency. A person employed by or acting under the control of the original agent in the business of the agency is a sub-agent. A sub-agent is responsible to the principal on which one of the following ground: willful wrong and fraud. The effect of ratification under the law of agency is retrospective. An agency under the Contract Act is terminated by principal revoking his authority, death of either principal or agent, principal being educated and insolvent. An agency can be terminated by principal revoking the authority, agent in renounce the business of agency, either the principal or agent dying. Under Indian Contract Act 1872, an agency shall be terminated by the below mentioned case: death or insolvency of the principal. An agency can be terminated by agreement between parties, the renunciation by the agent, by completion of business of agency. A give authority to B to sell a land and B pay himself out of the proceed. The debt is due to him from A. In the absence of express contract, A cannot revoke the authority nor can terminate it by death of insanity. A is in debt to B. He is authorized by B to sell his house and pay himself. Out of the sale proceed the debt due to him. In the absence of express contract, A can revoke the agency, A cannot revoke the agency. A can revoke the agency. Agency is terminated by A's death. A employee B recovered 1,000 from C through misconduct of the money is not recovered by B. Entitled to no remuneration must make goods the loss. An agent cannot claim remuneration for the misconduct under Section 220 of Indian Contract Act. B. The proprietor of newspaper published A request is liable C in the paper, and A agreed to indemnify B against the consequences of the publication and all cost of damage and the action in respect thereof. B is sues C and has to pay damage in all and also incur the expenses decided in the light of Section 224 of Indian Contract Act 1872. A is not liable to B upon indemnity. Which one of the following statement is a correct statement? An agency is not liable to act of disclosed principle subject to the contract to the contrary. An agent at the time of making the contract does not discloses the name and address of his principal, but it comes known to the second party afterward. In the case of any default of second party, may file a suit against either agent or the principal both. The principle of agency is necessary applicable in the emergent situation where communication with the principal is not possible. A consigns good to B for the sale and give his instruction not to sell under fixed price. C is being ignorant of the instruction given to B, enter into contract with B to buy the good at the price lower than the reserve price. A is bound by that contract. X entrusted Y with negotiable instrument endorsed in blank. Y sell them to Z, violation of private order from X. The sale is valid. A person appointed by the agent under the authority of principal known as substitute agent. Del Audrey against the kind of mercantile agent. Under the Indian Contract Act 1872, the following right is not available to an agent. Right to sale. Under the Contract Act 1872, which one of the following cases the presumption of an agent of the personal liability does not arise where the agent contract with the party who knows that the principal is a minor. A. The captain of B ship sign the bill of the land without having received or bought the goods mentioned therein, as between B, the pretending consignor, is concerned, the billing of the land void. When the agent of the contract, without disclosing the name of the existence of the principal in such cases, on knowing about the principal, the third party may file a suit against either the agent or the principal both.